Welcome back. I am the loud little ducky. Today we are going to go over the motion for lunch and the Owens v. Echard case. Alright, Gingras filed Maricopa County Superior Court, State of Arizona, in the matter of Owens v. Echard, motion to compel lunch and for alternate relief, assigned to the Honorable Judge Matta. Various procedure rules, e.g. Rule 9c, requires lawyers to talk in person or by phone before they file motions. Email discussions are not enough. But what if a lawyer refuses to talk with you? How can counsel complete mandatory pre-filing conference requirements of Rule 9c when opposing counsel won't accept your calls? Why are we doing hypotheticals in a document? Just state what happened. The judge doesn't want to play your mind games. The answer was provided nearly 20 years ago in a classic decision from the irreplaceable Honor Pendleton Gain, deceased, in Physician's Choice of Arizona v. Miller, a copy which is attached hereto as Exhibit A in Miller. Plaintiff's counsel wanted to speak with the defense counsel about potential settlement. Defendant counsel refused to talk, citing various concerns. Undaunted, plaintiff's counsel filed a motion to compel acceptance of lunch invitation, asking the court to recalcitrant, I don't know what that word is, but ordered the defense counsel to meet for lunch. In his order granting the motions, Judge Gaines explains, the court has rarely seen a motion with more merit. The motion will be granted. The court has searched in the vein in the Arizona Rules of Civil Procedure and cases, as well as leading to treaties on federal and Arizona procedure, to find specific support for plaintiff's motion. Finding none, the court concludes the motion of this type are so clearly within the inherent powers of the court and have been so routinely granted that they are non-controversial and require no precedential support. Physician's Choice of Arizona v. Miller, Minute Entry Order dated July 16, 2006, at 1. Emphasis added. By this same authority, undersigned counsel for Petitioner Owens moves the court for an order requiring respondent's counsel, Gregg Woodnick, to accept an invitation to meet for lunch. Without needlessly delving into details, there has been a communication breakdown between counsel, resulting in Mr. Woodnick refusing to speak with the undersigned counsel by phone. Mr. Woodnick may offer some explanation for why this has occurred, but that is mostly besides the point. If Mr. Woodnick chooses to describe his reasons, it would ultimately be counterproductive, since it would only lead to undersigned counsel to offer a detailed rebuttal. This would only expand the conflict, not narrow it. So instead of detailing the reasons leading to the communication breakdown, the undersigned offers some simple avowals to the court. Number 1. Undersigned counsel has now obtained a complete copy of Ms. Owens' files from her former attorney, Corey Keith. No further response has been received from Ms. Linvall's firm, but due to her belief participation in this matter, this is not a problem. The level of detail in Mr. Keith's files is sufficient to prepare this matter for trial. Upon reviewing Mr. Keith's files and looking at recent disclosures provided by Mr. Echard's side, it is clear this case is extremely complicated and there are many factual and legal issues counsel need to discuss urgently. Number 3. To offer the specific examples, A. Just days ago, on March 29, 2024, Mr. Echard provided a second supplemental disclosure statement. In this document, Mr. Echard disclosed for the first time that he intends to call 9 witnesses at trial, including 3 experts who were not previously disclosed. Despite this, Mr. Echard has disclosed no expert reports of any kind, nor has he disclosed the substance of each expert's testimony, the opinions to be offered by experts, if any, and the basis upon the experts' opinions were formed. All of that information is mandatory under not only Rule 49, but also Arizona Our Evidence 702 and Dubert versus Merrill, Dow Pharmaceuticals. be. Mr. Echards' extremely late and thus far incomplete expert disclosures raises the possibility and likelihood that Miss Owens will need to retain her own experts and or possibly bring a Daubert motion to exclude Mr. Echards' experts. However, due to Mr. Echards' failure to disclose sufficient information about what, if anything, his experts plan to say, it is impossible to know if a Daubert motion would be appropriate. Given this matter is set for a 2-hour evidentiary hearing, Mr. Echards' extremely late disclosure of 9 anticipated trial witnesses raises the possibility that Ms. Owens may need to ask the court to designate this matter as a complex case under Rule 50. For these reasons and many others, it is possible substantial additional motion practice may be needed in this case. Undersigned counsel is fully aware proceedings in the Family Law Department are generally less formal than typical civil cases, and the rules are often more relaxed. Nevertheless, because Mr. Echard is seeking to expand and aggressively litigate this case in the hopes of obtaining substantial award of attorney's fees, Miss Owens has no choice but to respond with the appropriate degree of care. That means Miss Owens must bring certain matters to the court's attention despite having no desire to do so, if only to protect the appellate record. Mr. Echard is not doing this for money. Does he want his attorney's fees paid for by Owens because of this ridiculous suit? Yeah, he does. But this is all about Owens admitting she lied and that this never happened. It is about clearing Echard's name, not money. But everything has to be money motivated with you, doesn't it, Gingras? For all these reasons, Mr. Woodnick's refusal to speak with undersigned counsel has created an impossible situation. This is an extremely complicated case, and it appears to be growing in complexity with each new and belated disclosure by respondent. Talk about late disclosures, not turning things in on time. Your client has failed to disclose the evidence she's supposed to in a timely manner. If there is any hope of resolving this case or even getting the case ready to be resolved in June, the lawyers have a lot to talk about. For that reason, just as Judge Gaines held in the physician's choice, good cause exists for the court under its inherent authority to order respondent's counsel to meet petitioner's counsel for lunch as soon as it is reasonably practically. Hopefully even later this week. Although undersigned counsel is optimistic, this request, if granted, will lead to more productive discussions between counsel, thereby removing the need for further assistance from the court in the event the problem continues. Ms. Owen further respectfully asks the court to waive the requirements of Rule 9c for the remainder of this proceeding. To support that request, Ms. Owens notes respondent has recently filed motions in which he either ignored Rule 9c completely, such as respondent's motion to withdraw motion for sanctions, or which he ignored the rule in the substantial part, such as respondent's motion to compel. As a matter of fairness, it would clearly be inappropriate to allow respondent's counsel to ignore Rule 97c, as he repeatedly has, by filing motions without first meeting and conferring in person. While respondent's counsel simultaneously refuses to speak with petitioner's counsel, as the rule requires, the rules should either be followed by both parties or the rules should be waived for both. Of course, the undersigned acknowledges the present motion was filed without an in-person or telephone consultation, although several attempts were made to discuss the problem via email. He has emailed you. So he has communicated with you, maybe just not in the way that you like. People be busy. For each of these reasons, Ms. Owens asked the court to issue an order compelling respondent's counsel to accept an invitation for lunch. In addition, and in the alternate alternative, if respondent's counsel cannot or will not speak with petitioner's counsel about pre-motion issues as required by Rule 9C, Ms. Owen asks the court to waive that rule for the duration of this proceeding. Signed by Gingras on April 8, 2024, and the copies of this filing were sent to Woodnick and Ms. Isabel. So here is the attachment of the Physician's Choice of Arizona v. Miller. This is a 2006 case that happened in Maricopa County, and Judge Pendleton Gaines is the one who wrote this judgment, or the ruling on this motion. So the court has reviewed the pending motions. 2 will be granted, the others will be deferred. Plaintiff's motion to compel acceptance of lunch invitation. The court has rarely seen a motion with more merit. The motion will be granted. And then this is the part that Gingras put in his motion. The court has searched in vain in the Arizona Rules of Civil Procedures and cases, as well as leading treaties on federal and Arizona procedure, to find specific support for plaintiff's motion. Finding none, the court concludes that motions of this type are so clearly within the inherent powers of the court and have been so routinely granted that they are non-controversial and require no precedential support. It goes on to say, the writers support the concept. Conversation has been called the socializing instrument par excellence. Jose Ortega y Gasset, Invertebrate, Spain. And one of the greatest pleasures in life, Somerset Maugham, The Moon and Sixpence. John Dryden referred to sweet discourse and the banquet of the mind, the flower and the leaf. Anybody read those? Plaintiff's counsel extended a lunch invitation to defendant's counsel to have a discussion regarding discovery and other matters. Plaintiff's counsel offered to pay for lunch. Defendant's counsel failed to respond until the motion was filed. Defendant's counsel distrusts plaintiff's counsel's motives and fears the plaintiff's counsel purpose is to persuade defendant's counsel of the lack of merit in the defense case. The court has no doubt of the defendant's counsel's ability to withstand plaintiff's counsel's blandishments and to respond Sally for Sally and Barb for Barb. Defendant's counsel now makes what may be an illusory acceptance of plaintiff's counsel's invitation by saying we would love to have lunch at Ruth's Chris with or on blank. Plaintiff's counsel. And then it's got footnote 1. Everyone knows that Ruth's Chris, while open for dinner, is not open for lunch. This is a matter of which the court may take judicial notice. Okay, so you can't have lunch there. And anybody who's anybody knows they only serve dinner. Plaintiff's counsel replies somewhat petulantly, criticizing defendant's counsel's acceptance of lunch invitation on the grounds that defendant's counsel is now attempting to choose the location and saying that he would oblige, but defendant's counsel will pay for its own meal. Yeah, they don't want your money. They can pay for their own meal. Thanks, come again. Who cares? There are a number of fine restaurants within easy driving distance of both counsel's offices. Example, Christopher's, Vincent's, Morton's. Oh my God, my brain once again doesn't function. I think my brain moves faster than my mouth. Donovan's, Bistro 24 at the Ritz-Carlton, the Arizona Biltmore Grill, Sam's Cafe, the Biltmore location, Alexi's, Sophie's, and if either counsel has a membership, the Phoenix Country Club and the University Club. Counsel may select their own venue, or if unable to agree, shall select from the list in order. The time will be at noon during normal business day. The lunch must be conducted and concluded no later than August 18, 2006. Footnote 2. The court is aware of the penchant of the plaintiff's counsel to take an extended cruises during the summer months. Each side may be represented by no more than two lawyers of its own choosing, but the principal counsel on the pending motions must personally appear. So they're saying the lead attorneys of the cases, they have to be there. You can't just send two people who are like second and third chair. Which stinks, but if it's what the judge orders, it's what the judge orders. You gotta do it. The cost of the lunch will be paid as follows. The total cost will be calculated by the amount of the bill, including appetizer, salad, entrees, and one non-alcoholic beverage per participant. Footnote 3. Alcoholic beverages may be consumed at the personal expense of the consumer. So you can drink alcohol, but that's going to be on your own tab, not a part of what we're talking about. At a 20% tip rate will be added to the bill, which will include tax. Each side will pay its prorated share according to the number of participants. The court may reapportion the cost on application for good cause or may treat it as a taxable cost under ARS 12-331-5. During lunch, counsel will confer regarding the disputes identified in plaintiff's motion to strike, defendant's discovery motion, and defendant's motion to quash, for protective order, and for commission authorizing out-of-state depositions. Footnote 4. The court suggests that serious discussion occur after counsel have eaten. The temperaments of the court children always improved after a meal. So none of these discussions, the serious discussions, while you're possibly hangry. Get some food and settle your stomach and plan to be there for a while. And let's see. At the initiative of Plaintiff's Counsel, a brief joint report detailing the parties' agreements and disagreements regarding these motions will be filed with the court no later than 1 week following the lunch, and in any event, not later than noon, Wednesday, August 23rd, 2006. So you have a week to give me a report about what happened on y'all's lunch date. Defendant's motion to strike proposed amended complaint. To demonstrate to counsel that the court has more on its mind than lunch, the court has considered defendant's motion to strike plaintiff's proposed amended complaint. The motion will be granted. Plaintiff's proposed amended complaint is 56 pages long and has 554 separately numbered paragraphs. It contains 19 counts. It is prolixed and discursive in the extreme. It violates the court orders of July 22nd, 2005, permitting the plaintiff to file an agreed-upon form of amended complaint to clean up housekeeping matters. It is not the short and plain statement required by Rule 8A2. It is a pleading of type of specifically condemned in Service Insurance v. Albrecht. Trial court should have stricken 269-page and 1,322 second paragraph complaint. Most importantly, it violates the observation of French philosopher Blaise Pascal, who concluded a long letter with an apology saying he had not the leisure to make it shorter. Since this is a 2003 case with no end in sight, plaintiff's counsel has the leisure to make his complaint shorter. And then it says, order, it is ordered. Plaintiff's motion to compel defendant's counsel acceptance of lunch invitation is granted on the terms and conditions set forth above. The parties are directed to file the joint report referred to above. Further action on parties pending discovery motions is deferred pending receipt of the joint report. Defendant's motion to strike plaintiff's proposed and amended complaint is granted. And the last one, the oral argument set in this division on August 2nd, 2006 at 9:15 a.m. is vacated. So that is the order that Gingras is referring to, and he would like an order that lays out this stuff for him and Woodnick to go to lunch. So there we have that. That was quick and easy. The next one is not going to be so quick because we have Woodnick's response coming up next. Our quote of the day is, no matter how educated, talented, rich, or cool you believe you are, how you treat people ultimately tells all. Integrity is everything. And it's something we all need to keep in mind. A particular attorney needs to keep in mind because he likes to brag about all the things and how awesome he is. But he lacks integrity. So he needs to get some. But I will see you in the next video, and hope y'all have a wonderful day. Hit like, subscribe, turn that notification bell on, and I will see you later. Bye.
Loud little ducky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. A sparking revolution, it's a truth-telling tale.